Hi, everyone. Thank you for joining us today for Constangy's webinar. Are you ready for the CPRA, CCPA Take 2, What You Need to Do? A couple of housekeeping items before we get started. Today's webinar is approved for SHRM credit and is pending approval for HRCI credit. We will provide those codes to you at the end of the presentation, so please stick around in order to receive those. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Ron will leave some time at the end to answer your questions. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. I'm now going to turn it over to today's presenter, Ron Sarian.
Good afternoon, everybody. I'm Ron Sarian. I am Senior Counsel at Constangy and am Chair of the Electronic Workplace and Data Privacy Practice Group. By way of background, I spent the first 2+ decades of my legal career as a business litigator. I started out with a big firm downtown LA, then I went to a boutique firm where I was present for 20 years, became a partner there. Somehow I ended up becoming general counsel at eHarmony, which was an absolutely wonderful job. And that's where I really developed an interest for privacy and cybersecurity. I was at eHarmony for 5 wonderful years, and then we were acquired. And I found my way over to Constangy as, again, a senior counsel. And I'm practicing in information privacy and cybersecurity. In December of last year, I was honored to have been asked to become an adjunct professor at USC Gould School of Law, teaching information privacy. So I'm currently teaching my 2nd semester, and I'll be back for my 3rd semester in the spring. So anyway, with that said, let's get into the CPRA. You're probably all familiar with the CCPA, which is the California Consumer Privacy Act, and now it's being amended and superseded by the California Consumer Privacy Act. And so I think what we need to do is we need to look at the purpose and intent of the act. And really what it is just common sense and equity. Basically, consumers should have a right to know what type of data is being collected from them and who is collecting their personal information. Consumers should be able to control the use of their personal information. Consumers should have access to their personal information and be able to correct, delete, and take it from one business to another. And this is the preamble that I'm reading actually directly out of the CPRA. Consumers or their authorization should be able to exercise those rights through easily accessible self-serve tools. And this is important. Consumers should be able to exercise those rights without penalty. Consumers should also be able to hold businesses accountable for failing to take reasonable precautions to protect their PI. So businesses do have to take reasonable security procedures, which we will get into shortly. Consumers should also be able to benefit from the business's use of their personal information. And now with the CPRA, these rights were extended to employees and business to business. Technically, employees and B2B contacts were always covered by the CCPA, but there was an exemption for the first couple of years of the CCPA, which expired expired January 1, 2023, and now was superseded by the California Privacy Rights Act. So we have employees now to worry about, and there are a number of things that they will have a right to do that previously only consumers had a right to do, which is going to create a whole lot of work for businesses and a whole lot of intense focus on what businesses are doing with employee information, as well as what employee information is collected. And that's going to take some effort. So who are covered entities under the CPRA? Basically the same as CCPA. And that is that it's for-profit entities that do business in California and collect the personal information of California consumers. And we'll get into what a consumer is, but basically they have to meet one of three requirements in addition to being for-profit and collecting the personal information of California consumers. One, as of January 1st of the year, would have had gross sales in excess of 25 million for the preceding calendar year. And that is gross sales worldwide. That is not sales in California, that is gross sales worldwide. Or you have to buy, sell, or share the personal information of at least 100,000 California consumers or households. And that's a little bit of a nod to businesses, actually, because under the CCPA, they would have only had to buy, sell, or share the personal information of 50,000 California consumers or households or devices. Previously, they had in there to remove devices from the new CPRA. Or number three, derives at least 50% of its annual revenues from selling or sharing California consumers' personal information. And it may apply to businesses, covered businesses that process the California residents' personal information, no matter where that business is located. I know we get this question a lot. Well, I'm located in another state. Well, if you're doing business with California consumers and you comply with those requirements, you're for-profit, you collect their information, you have one of those three things in place, you're going to be subject to the CPRA when it comes to a California consumer. So what is a protected California consumer? Well, simply, that is anybody who is domiciled in California on anything other than a temporary basis. It's a very broad definition, and is really a little bit amorphous. But anybody who's living here on anything other than a temporary basis is going to be considered a consumer. And of course, that would include employees or business-to-business contacts or any natural person who's here in anything other than a temporary basis, or every California domiciled individual who's temporarily out of California or out on a transitory basis. So if you're a California consumer and you leave in a business and you do business with a company that's subject to the CPRA, and even though when you're doing business with them, you may be in Nevada or Arizona or Maine, and if you're only there for a temporary purpose, well, guess what? CPRA is going to apply to that. So the big question is personal information. And this is an extremely broad definition. It encompasses so many things, things that you don't necessarily realize would be personal information, but it's defined in the statute as any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So this can include so many things, identifiers such as IP addresses, electronic network activity, browser history, search history, job applicant information, CV information, audio, electronic, visual, thermal, olfactory, geolocation, biometric, genetic, inferences that are drawn from PI to create a profile about a consumer reflecting their preferences. And of course, we'll get into that now because the CPRA has a special new section that deals with drawing an inference from sensitive information. In any event, it is an extremely broad category. So what you need to do as a business is take a look at, and you have to do some very extensive data mapping and determine exactly what type of personal information you're collecting from, number one, people that use your website or business, and number two, of course, your own employees. And that's going to be actually a much broader category, which we'll get into shortly. So overview of the rights provided. And this kind of goes back to the initial purpose and intent of the CPRA. The first right is the right to know the categories of PI collected from the business, by the business from the consumer, and whether it's sold, shared, or disclosed, as well as the categories of third parties with whom the PI was disclosed, sold, or shared to. You have the right to access a copy of the business, of the PI the business retains, as well as to transport it. You also have the right to access the logic the business uses to process the information, which is a new requirement with the CPRA. You also have the right to correct any inaccuracies that you see in the information that the business collects. And this is a new requirement of the CPRA. And this could lead to some issues when it comes to employees, when it comes to things such as investigations and other confidential matters, which we'll discuss in a few minutes. You also have the right to delete or have the business delete the personal information they withhold from you. Of course, that's subject to a few exceptions, such as if it's necessary to conduct the business that you've done on the website to conduct. But this also can create questions and issues when it comes to employees, as far as requests for the business to delete certain information when the business is otherwise required to keep it pursuant to legal requirements. Next is a big one, and that is that you have a right to opt out of the sale or sharing of the business's use of the personal information or the business's use of sensitive information, which we'll get into shortly. Under the CCPA, you have the right to opt out of the selling of your personal information by the business. That's now been broadened to sharing of the personal information or the use of the sensitive personal information by the business. Next is the right to equal service. If you opt out, and that is really just kind of a fundamental right, and that is to not be discriminated against if you do not want the business to sell or share your personal information or use your sensitive information for a purpose that you don't approve of. The business cannot refuse to do business with you if you opt out of the business selling or sharing or using that information. Again, there are exceptions, and the exception would be that if you can't conduct business without, the business cannot conduct business with you for the purpose you came on the business's website. If they can't do it without that information, then obviously what they have to do is say, we can't service you and we can't use our website. And in fact, that happens all the time. And the next is a private right of action, which actually existed under the CCPA. And it allows a consumer to sue a business in the event that there's a data breach and the consumer's personal information is improperly exfiltrated, accessed, or disclosed, and the business did not use reasonable security procedures. So the consumer has a few hurdles to jump over if there was a data breach. The biggest being that they have to establish that the business is not using reasonable security procedures, and we'll get into that in a second. There was a right to cure originally. Now it's been modified, and it's a little bit hazy actually currently, but we'll get into that. Okay, so let's talk about the right to know, to access, to correct, and to delete personal information that a consumer or now an employee or business-to-business contact would have. Number one, there has to be a verifiable request for the right to know, access, correct, or delete. And a verified consumer request basically is made on behalf of the consumer or on behalf of the consumer's minor child. And the business has to be able to reasonably verify that the consumer is who he or she says he or she is. And the requirements for verification must be reasonable in light of the type of personal information requested. There has to be, and of course, that's all going to be very amorphous. I mean, you have to determine, what type of information is being requested and what you need to verify that this person is who the person says he is. And that's going to depend on the structure of your business. But you have to make a reasonable verification. And if you cannot reasonably verify the person is who they say they are, you cannot give them the data, because if you do, it would be considered a data breach. So that's something you have to look at very carefully. The CPRA also requires that you provide appropriate links and telephone numbers for the request. And you cannot ask the consumer to provide any new personal information to verify existing personal information. which makes sense because you don't want to be soliciting any additional personal information because that would be required to be disclosed, and all the other bells and whistles would be triggered under the privacy law. So if the request is deficient, the business must inform the consumer how to correct the request. Of course, you can't give away too much, but you can say, you know what, we need you to provide some additional information. Again, not any new information, but information the business already has. You have to tell them how to correct the request. So, and the consumer can make up to 2 requests in a 12-month period. So there is a time frame within which to respond to a consumer or employee request. Number 1, the business must first confirm receipt of the request within 10 business days following the request, and inform the consumer of the actions that it will take to comply with the request. Thereafter, it must comply with the request within 45 days of the request. And it can seek an additional 45 days if within the first 45 days, it tells the consumer what it's doing and why it can't get the information within the first 45 days. Then it's entitled to an automatic additional 45-day extension, but that's it. My advice would be to try to get everything resolved within the first 45 days. And of course, to do that, you'll have to do data mapping. And as we'll get into shortly, you'll have to make sure your employees are very well trained to deal with consumer requests and comply with them within the statutory timeframes. After, with regard to a request to delete, the business has an additional obligation, and that is to inform the consumer whether it has complied with the request and confirm that it will maintain a record of the deletion request. That is what it's required to do under the CPRA. So, when you get a request from a consumer or an employee to know what type of data that you hold, you can provide either the categories or specifics depending on how the request is worded. But it's going to be for all data collected from January 1, 2022 to the request date. Under the CCPA, it was only a 12-month look back from the request date, but with the CPRA, the look back actually starts January 1, 2022, and it will go on indefinitely into the future. So if a request is made in the year 2030, you're going to have to supply all the data that went back, that you keep as far back as 2022. Now, let me caveat that. You may not want to keep data unless you're required by law to do it, because keeping extra data for extra period of time just exposes you to liability in the event there's a data breach. And I know that the carriers do not want to see, carriers of cybersecurity insurance do not want to see the company maintaining or holding any data for any longer than the period they actually need to hold the data. And that's also a requirement that there's going to be data minimization, and that you only hold it for the period as long as you need to keep it to do the undertake the actions that the consumer came to the website for you to undertake, or for employment purposes, for whatever the purpose was that you obtained the data from the employee. That's something you need to look at very carefully. And the response can be by mail or email in a portable, readily usable format, allows the consumer to transmit it without hindrance to another company. That would be when you tell them what the data is or provide the actual data. If categories are requested, then you must describe those categories in the privacy policy and the notice of collection. Categories of data collected should be always described in the privacy policy and notice of collection in any event. And we'll get into what the notice of collection is in a little bit. But one of the foundations, again, one of the purpose and intent of the CPRA and the CCPA is so you know what data is being collected from you. And the way you know that is by its description, or at least a description of the categories of data collected in the privacy policy, and then in the notice of collection at the time, at or before the time the data is actually collected from the consumer or the employee. Now, with regard to the request to know if they request specifics, like they want you to tell them precisely what type of data is requested, then you have an obligation to do that unless it's going to disclose or reveal some type of trade secret or other type of sensitive information that you really don't want to disclose. And you really need to have your lawyers look at it when they're requesting something very, very specific. And then this can blend also into the employee context. For example, if they're requesting investigation files and records, things of that nature, disciplinary records, you may or may not want to be able to may or may not disclose them. You want to disclose them, and you may have a basis to withhold them, but that's something you need to consult your attorney with on a case-by-case basis. You can never disclose under the CPRA. You can never disclose Social Security number, driver's license, government-issued ID, financial account numbers, health insurance info, medical identification numbers, passwords, security questions, answers, unique biometric data. Those things are defined as being not disclosable. So you can disclose all the other information requested. Again, if it's appropriate for you to disclose that, but those you can't disclose. Now, if information is withheld for security or any other purpose, as we just discussed, you must disclose the reasons for non-production. And you can basically say that in general, what those reasons are without disclosing or giving away any type of secret. Okay, so with regard to a request to delete, when you receive a verifiable request, you can either permanently delete it, completely erase the PI, which most companies don't do. I know that certainly that many of the companies I deal with, when they attempt to permanently erase or completely erase PI, it somehow interferes with other systems and it causes a mess. So you can also de-identify the PI so it cannot be re-identified, or aggregate the PI with other PI so it cannot be re-identified. The key is that it has to be permanent, and you cannot be able to reassemble it and trace it back to the individual once they tell you to delete the information. And if you as the business has provided the information to any other entity, you have the obligation to instruct the entity who has the PI to also delete it and assure that they do it. And again, business shall inform the consumer of the deletion and they maintain the record for up to 24 months. But as I indicated earlier, they have to inform the consumer of that. And if you can't delete it, you also have to inform them of the basis of why you can't delete it. Okay, so this goes back to what I was touching on before. Businesses do have exceptions, to deletion. That is, if the information is needed to complete a transaction for which it was collected, or was used in the context of ongoing business relationship with the consumer, or required to perform a contract, used to detect security incidents and protect against malicious or fraudulent activity. So we have a lot of exceptions here. Needed to engage in scientific, historical, or statistical research in the public interest. You may qualify for one of those. Or used solely for internal purposes aligned with the expectations of the consumer. Required to comply with a legal obligation or applicable laws, and that's a big catch-all because you have a lot of other laws, especially in the employment context, like FMLA, or you have ECBA, Electronic Consumer Protection Act, that requires you to maintain data for a certain period of time. I just got a question: is the employee's business email address and business IP information considered personal information? Yes. They can trace it back to the employee. The answer is yes. Okay. All right. So opt-out rights. Now this is the big one. As I indicated, we had opt-out rights under the CPRA and under the CCPA, but only related to sale. But now it's been broadened to sharing or also the use of sensitive personal information. So the first thing we have to do is look at the specific definitions. And frankly, I mean, everything in the CPRA is very definition intensive. So you actually need to look at the statute because it's a very technical statute. And well, I guess most statutes are as laws, but Sale is defined specifically in the CPRA as the selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally, in writing, or by electronic or other means a consumer's personal information by the business to another business or a third party for monetary or valuable consideration. And the word valuable consideration is a really huge catch-all, because, for example, if you provide personal information to a data analytics company like Google Analytics, for example, and they don't charge you for their services, but they ask you to provide them with personal information, and in return, they're going to give you analytics. Well, guess what? That's valuable consideration. That's considered a sale of personal information. That's going to have to be disclosed, and your consumers or employees are going to have a right to opt out of the sale, quote unquote, of that information. Sharing is basically got an identical definition for the most part to sale, except that they start with the word sharing. The rest of it's the same, except it's used for the purpose of cross-context behavioral advertising, whether monetary, whether or not monetary, for any other valuable consideration. So basically, if you're using PI of a consumer or an employee for the purpose of using targeted allowing targeted advertising to be leveled against or sent to that consumer or employee, they have to have a right to opt out. So you have to look at basically the definition of cross-context behavioral advertising, which is defined as the targeting of advertising to a consumer based on a consumer's personal information obtained from the consumer's activity across businesses, distinctly branded websites, applications, or services other than the business. Distinctly branded website, application, or service with which the consumer intentionally interacts. So the consumer came to you for one reason, and somehow you're using, you're looking at the browser, you're putting cookies on their browser, and you're somehow supplying those cookies, or you're using that information to target advertising to them. That's basically considered cross-context behavioral advertising. The same for an employee if you're monitoring the browsers of their work websites, of their work computers. And so you got to be very careful about that in the employment context, because you may be looking at that for the purpose of either profiling, which is also going to be provided an opt-out, or providing them with certain services such as financial services or stress counseling services or things like that. Those are things that are going to need to be looked at very closely by a business, and the business is going to need to determine if the way they're doing it is considered cross-context behavioral advertising. Because if it is, then the consumer and or the employee is going to be able to opt out of that. So here's the opt-out rights. Where the data is sold or shared, a consumer or employee must be provided the right to opt out, and that is through either a quote-unquote do not sell, share my personal information link on the privacy policy. And I suggest that companies produce a bespoke privacy policy for their own employees as opposed to a simple online privacy policy for just general consumers who go visit the company, because employees have these rights. And of course, you're going to have to determine what you're going to allow them to not, to opt out of, because you may need to do certain things. And again, that's something you need to consult your attorneys about. Okay. Because employers collect so much data, including browser information, even cell phone numbers, they have their work cut out for them. So we have a new category of information in the CPRA called sensitive personal information. And here's a specific definition of it. It includes but is not limited to, and again, this is personal information, but it's just it receives heightened scrutiny because it's more sensitive and more bad things can happen if it's disclosed wrongfully. And that includes a social security number, driver's license number, passport number, account login name and password, geolocation data, racial or ethnic origin, religious or philosophical beliefs, union membership, contents of a mail or email or text message, genetic data, biometric data, processing of biometric data, of course, and genetic data, and sexual orientation or preference. That's all very sensitive personal information. So there is a greater potential for harm. So you must take the appropriate procedures to make sure that that is adequately protected. And we'll get into what reasonable security procedures are. But if you are collecting any of that information, it's got to be specifically disclosed through the privacy policy and the notice of collection at or before the time it is obtained. And again, you need to look at this when you're talking about employees and job applicants. And as we'll get into, a job applicant is considered an employee and a consumer that's subject to the CPRA. So, potential issues for employees. I mean, is this sensitive information used to provide health, counseling, financial services, as I indicated, or is it used for diversity and inclusion efforts? Used for predictive analytics to determine, for example, if you're going to give someone a raise or promote someone or demote someone? You better look at that very carefully, because that's a use that potentially would allow an employee to opt out of it. An exemption is if it's reasonably expected by an average consumer that this will be collected, gets into gray areas. I mean, would an employee reasonably expect you to collect that information? If so, you would have an argument that you don't have to delete it, but it's getting into a gray area, and it's something you definitely need to consult with counsel on. Hold on, I got a question here. Yes, what about the information the state of California requires ethnicity? Well, that would give you an exemption, doesn't it? Because the state requires you to obtain that information and hold that information. So you would arguably not have to allow an opt-out of the retention of that information, use of that information for the appropriate business purposes. But again, it's something you're going to need to consult an attorney with, consult with an attorney about. Okay, so if it's used for any purpose other than specifically disclosed in the privacy policy or notice of collection, then you have to provide an opt-out. And the opt-out would take the form, and this is a language required by the code, limit the use of my sensitive personal information. It's just an opt-out, just like do not sell or do not share my information, but it has to be a hyperlink. Or if you only do business on paper, there's got to be a separate paper that's got that language on it and allows them to submit it to you and you take action. Another addition to the CPRA is if you're inferring characteristics of a consumer or an employee, an opt-out may also be required. This goes back to what I was saying, what I previously said, and that is with regard to, are you inferring that an employee is going to do certain things by what you're collecting from them? If so, you may need to opt out, and that's something you have to look at very, very carefully. Okay. The opt-outs need to be provided at the time of collection of the information through a quote-unquote clear and conspicuous link on either the homepage of the website entitled what I just indicated, do not sell my personal information or share my personal information or limit the use of my personal information. When you also collect it and you're providing a notice of collection, they need to have a right to opt out. Again, if you're going to provide them with a right to opt out based on your business circumstances. There also must be at least one additional method, including but not limited to a toll-free number, a designated email address, a form, or a global opt-out signal, which we'll discuss shortly, because that's another requirement of the CPRA, and that is if the user of the website has enabled the global do not share, you have to have the means to detect that and to honor it. And it can be problematic, and we'll talk about that in a minute. So following the opt-out request, the business must wait 12 months before they can contact the consumer again to get an opt-in to sharing the same information they opted out of. So this can present problems when it comes to employees. Okay, so there are exceptions to opt-out rights. There are exceptions to everything. Again, if the consumer uses or directs a business to intentionally disclose the personal information to a third party, as long as the third party does not resell it. Consumer uses the business to intentionally interact with a third party. A business uses or shares a PI that is necessary to perform a business purpose. And of course, that's a very big and very broad exception that a business could really rely on for a lot of things. Or if the PI is transferred as a part of a merger or acquisition, in which a third party assumes complete control of the business. So the time period for requiring compliance with an opt-out request is basically 15 business days. Unlike complying with a request to know, to access, to delete, or to limit the sharing of sensitive information, an opt-out of, you have 15 business days to comply with a request to opt out of the selling, sharing, or use of the sensitive information, as opposed to non-sensitive information, which is a longer period of time. You have to honor the request for 12 months before asking the consumer to opt in again, and I just indicated that. And there's a two-part procedure to opt back in. So the legislature has made it difficult for a person to accidentally opt in once they've opted out. And that is, the consumer must first clearly request an opt-in, and then they must separately opt back in. So here's another area where we have another potential opt-out request, and that is, and I kind of touched on this, automated decision-making and profiling. I mean, there's technology to profile consumers based on their performance, economic situations, personal preferences, interests, reliability, behavior, location, and movements. Similar to the protection of sensitive personal information, consumers, including employees, will also have a right to access the business's automated decision-making technology. So you'll need, as a business, you'll really need to look at that automated technology, what you're using. Again, if you're profiling a consumer or employee for any of these business purposes, you're gonna need to look at what you're doing and determine whether that's a legitimate business purpose or that would be a reasonable employee expectation. There's a hell of a lot to think about. The parameters of the right to opt out of such use really have not been clearly defined yet. There's still things going back and forth because the regulations have not been finalized, and there's still a lot of back and forth on it. And by the way, the CPRA will not be actually enforced until July 1 of 2023, but the CCPA, which has many or most of the same requirements, is of course completely enforceable and has been since July 1 of 2020. So you just need to make sure you got your act together. So opt-out may be required, but you're going to need to consult with the lawyer, and it's going to be based on very particular parameters. So use of enabled global privacy controls is what I was talking about before. These are essentially basically a data switch that's available on just about any browser. It tells any business, if you're using that browser and you go to a business's website, to not sell the consumer's personal information. Your business has to be wired and coded to honor a global privacy signal. If you don't do that, you can have some issues. Now, there's some disagreements as to, and the regulations haven't come out yet as to exactly how to implement this, because there are sometimes potentially conflicting signals. But you'll need to sit down with your IT people to make sure that this is enabled, and how this applies to other opt-outs. Let me tell you how that applies. If the business honors the global opt-out, then according to the actual statute, the CPRA, then they could skip offering the do not sell, do not share my PI or limit the use of my PI or sensitive PI links. But you know what? I'd still include all those links because you want to look like a Boy Scout or a Girl Scout if there's ever any regulator looking at you and determining, whether or not you're behaving or not behaving. Now, many of you may have read about the $1.2 million fine that our California Attorney General just levied on Sephora for failure to honor a global opt-out signal, as well as failure to disclose precisely what it was doing with consumer information. Now, they no longer have to provide any notice to cure as far as that goes, but in this case, they did provide a notice to cure. I mean, there were apparently repeated letters from the Attorney General's office to Sephora telling them to fix this problem, and they didn't comply with it, so the AG slapped them with a $1.2 million fine. So it's something to take very seriously. And now, and we'll get into this in a second, but now with the CPRA, there's a brand new agency called the Consumer Privacy Protection Agency that's been created expressly for the purpose of enforcement of the CPRA. And they will work in conjunction with the AG's office, but they are going to be the authority to police compliance. So the next right, this is the second to last right that's provided, material right that's provided to consumers, is the right to be treated equally and not be discriminated against if they request to opt out. And so be advised that an employee can assert this right if for some reason the business decides that it's not going to delete information the employee requests, even if it does it for a business purpose. You'll have to consider the employee rights here. And a claim that an employee can make is that, well, you know what, you're discriminating against me or whatever, because I should still be able to do A, B, and C, but because I'm requesting that you don't take certain information, I should still be able to do A, B, and C. It's going to be, it's all going to be very fact specific and depend on what information is being collected and what the business is doing with it. But businesses, again, need to look very, very carefully at absolutely everything that's being collected from employees and what they're entitled to participate in and not participate in. And if that's tied to personal information, providing personal information, we have to look at that very carefully if the employee does not want to provide personal information. Okay, so last material substantive right is the private right of action for data breach. As I indicated at the outset, if there is a data breach and it's determined that the business was not utilizing reasonable security procedures, and the lack of those reasonable security procedures are what led to a, quote, unauthorized access and exfiltration, theft, or disclosure of unencrypted and unredacted personal information, there's no need to establish damages, okay? So again, hyper-technical language, and that language needs to be followed very carefully, because if you arguably had redacted the information or it had encrypted the information, then, and it's still removed without authorization, arguably there's not going to be a private right of action against you. And this now, under the CPRA, has been expanded to if the breach exposes email addresses and a password or a security question. Before it was just personal information, but now it's email addresses, which are personal information anyway, and a password, which may not necessarily be, but if they allow someone to tap into an email, that's going to be considered subject to the data breach private right of action provided in the CPRA. And so the big issue here, or the big benefit to the consumer or even the employee, is that they can recover $100 to $750 per breach per incident, or actual damages, whichever is greater. Typically, it's very hard to show actual damage or establish any damage from a data breach, although sometimes people can do it. For example, somebody applies for a loan in someone's name with wrongfully stolen credentials, and they can establish damages. But usually it's very hard when you haven't actually been able to determine what, if any, damages occurred. But guess what? You don't have to show that. You get statutory damages of $100 to $750, you being the consumer or the employee, if you just show that the business was not utilizing reasonable security procedures. So that's a biggie. We will go over what, wow, I need to hurry up here, what reasonable security procedures are. Basically, it's a negligence standard, and that is basically what is a best business practice. And that is going to be dependent on your industry and the type of information that is maintained. So technically, a employee or a consumer can ask you to cure the problem with a 30-day notice, identifying the specific provisions that were violated. And if the business cures, there's no statutory damages, but it's a really ticklish area, and it's really not clear because the code also says if reasonable security procedures are not in place beforehand, there is no curing. You can't cure it. So it's the bottom line is get reasonable security procedures in place. Okay, CPRA does not apply to publicly available information, health or medical information governed by Gramm-Leach-Bliley Act, HIPAA or CMIA, which is California Medical Information Act, or the Fair Credit Reporting Act. And they shall not restrict the business's ability, and we've kind of touched on this, to comply with federal, state, or local laws, comply with investigations, subpoenas, or summons, cooperate with law enforcement agencies, exercise or defend legal claims, so on and so forth. So there are a lot of general exceptions to compliance too. So CPPA, the California Privacy Protection Agency, again, as I indicated, is the new state agency that's now going to be the policeman, in addition to the Attorney General, who's overburdened with requests with regard to CCPA, alleged CCPA violations. And so if you are in violation of the CCPA, regardless of a private right of action that may exist for data breach, the California Privacy Protection Agency and the Attorney General's office can issue fines of $2,500 to $7,500 per violation. And 75 is for the intentional violation, with no maximum caps on penalties. Well, we just saw that. So here's some other unique CCPA or CPRA requirements. You are now required to disclose in your privacy policy your document retention policies. So you're going to need to, number one, establish what your document retention policies are with regard to each category of personal information that you collect as a business. And of course, employees have a right to know what you're doing there too. Again, I would suggest a bespoke employee privacy policy due to the additional information you're requesting from employees. If it's not possible to provide if it's not possible to provide all the exact categories of information and retention periods for each category, then you have to provide how you're trying to determine what those categories are. So there's some work that's going to be cut out for a business in that regard. But they do need to be clearly laid out in the privacy policy. Right to cure deficient compliance eliminated. As I touched on earlier, there is no more 30-day right to cure any deficiency other than that quote-unquote right to cure for a private right of action. But as far as the AG is concerned, if you're in violation of the CPRA, you're going to be paying penalties right away. So that's something that you need to be very much on top of, at least have in the forefront of your mind, because you're not going to get a chance to fix it. Although, frankly, if the AG or the CPPA contact you, they may give you a chance to fix it, but that's certainly not what's required in the law. You also have to engage in data minimization, which is kind of a GDPR standard, which is, of course, a European General Data Protection Regulation, which is only use the data that only collect and use the data that you're absolutely required to use for the purpose of conducting business. Do not take in any extra data. It's just a liability if you do. We also have to conduct annual risk assessments in the The regulations are still out with regard to how this is going to be done. But you have to basically look at internal cybersecurity issues and privacy issues, and they must include whether processing involves consumer sensitive personal information and identify and weigh the benefits to the business, consumer, other stakeholders, and public from the processing against potential risks to the rights of the consumers data is being processed. There's also, if you're providing financial incentive, you have to disclose certain requirements, basically what the value of the incentive is worth, and typically that they would have to opt into that use. In summary, basically, you have to provide an incentive with a price service difference, the material terms of the incentive. This will also be in the privacy policy, how they may opt into giving this financial discount, and how a consumer can withdraw at any time. And you must explain why it's reasonably related to the value of the consumer's data. This is in the privacy policy. And a good faith estimate of the value of the consumer's data, the method used to determine that value. Well, guess what? That's not going to be easy. All right, so minors, children of 13 have to be verifiably opted in by the parents. Between 13 and 16, either the parent or the kid can opt in, or typically it would be the child can opt in from 13 to 16. And they must adopt, the business must adopt a method to reasonably assure all of the foregoing, and fines have been tripled under the CPRA for that. So what to focus on now? Privacy policy, notice of collection, those are external facing documents, and those are things that are external facing. So you know that people are looking at it, lawyers are trolling your websites, the AG may be trolling your website. So you need to get those in order. Internally, of course, you have to have the necessary infrastructure, mechanics, vendor contracts, employee rights, and reasonable security procedures. So privacy policy has got to include a conspicuous link with the word privacy that must be displayed on the website homepage, or download a landing page in a mobile app, or otherwise made conspicuously available to consumers. And the answer is yes, the materials will be shared. I know there's quite a bit here, and I need to hurry up a little bit. Anyway, it has to be easy to read with straightforward language, in a language that a business ordinarily uses to do business in California. So if you have a website in Spanish, the privacy policy needs to be in Spanish. WCAG 2.1 accessible. Actually, the whole website in California should be ADA website compliant, and it should be in a printable format in case someone wants to print it out. You've got to state whether or not the business sells or shares personal information, whether it collects sensitive information and its use. Explain the consumer has the right to know, access, delete, correct, opt out, as we discussed earlier. Those all have to be laid out in the privacy policy. Provide instructions on how to submit the request to delete, correct, opt out, to know, including the methods for submitting it. Describe general process the business will use to verify the request. This all has to be in the privacy policy. And these rights, actually all the rights, should be updated every 12 months or whenever something is changed. You also, in the privacy policy, need to confirm the right for non-discrimination for exercising any request, and describe the document data retention policy, as I just indicated. And there's going to be a lot of thought that needs to go into what your retention policy is and the particular types of data you hold, as well as how long you hold that data for. Instructions on how to appoint an authorized agent, and you can appoint an authorized agent to make these requests for you, and state whether or not you have actual knowledge of selling PI to minors under 16. And you have to provide when the date the policy was in place, and contact information. But it's important that you do provide the date the policy was last updated, and it updated at least once a year, if not more. And again, if there's something new that you're doing, it needs to be updated. Notice of collection is basically very similar to the privacy policy, but it basically discloses exactly what you're going to be collecting from either a consumer or an employee before they actually put it into the machine or provide you with that information. I like to make the notice of collection as broad as possible, and I have some forms that if anybody would like to see what they look like for employers, I'd be happy to send them to you. The notice needs to be readily available, just as the privacy policy and conspicuous link. They can be one joint document, but everything needs to be disclosed in that document. It could say privacy policy / notice of collection, and then someone needs to click on that before they, or click that they've read that before they provide any personal information. So last question, should you have the notice of collection hyperlink next to a privacy policy or combined link? That's going to be up to you. Some of my clients like combined links, some of them have separate links. And of course, just as with everything, you can't use PI unless it's specifically described in the notice. If nothing is sold or shared, no notice of collection, and it's not directly collected from the consumer. In other words, if you're purchasing it from if you're purchasing personal information from an entity like Target Smart or something like that, you do not need to provide a notice of collection because there could be hundreds of thousands of consumers. But you do need to indicate in your privacy policy that you are utilizing the type of information you're purchasing. So internal facing documents, adequate training is critical. You need to instruct and train all your employees responsible for handling personal information about how to deal with these consumer requests or employee requests, and they have to know how to deal with them in the time frame that's provided by the CPRA, which is, you have to give them a response within 10 days telling them what you're going to do to try to get the data, and then you have to give them the data or take other appropriate actions within the time frames provided by the statute, like to opt out of the sharing of, opt out of the use of sensitive information, 15 days, to delete information, 45 days, to provide information or access to information, 45 days. So those are things that your employees need to be well trained on. And of course, you have to have the infrastructure in place so they can find that information within the time period specified. So next we have, I'm going to go over this quickly. There are a number of categories of, I'm going to call them vendors for lack of a better term, although the third party is not technically a vendor. But we have service providers who are basically the entities that process your information. They have to have specific requirements in their contracts, and there are a lot of them. And I'm not going to go over them all now. I will provide this deck. And this is not necessarily exhaustive, but these are the key requirements that they have to be in a vendor agreement, such as they're not going to retain, use, or disclose the information for any purpose other than specified in the contract. They cannot commingle it with their own assets, combine it with their own personal information. You have to allow the business to inspect them and so forth, and they have to require any subcontractor they use to sign on to the exact same type of an agreement. A contractor is a new category of a vendor that's listed in the CPRA, and basically it's anybody. It's basically the same as a service provider, although a contractor generally doesn't process data, but they must have all the same procedures in place and contractual provisions in place, and the contracts must also include a certification, which is not required of a service provider, but a certification that they understand and will comply with all the service provider laws. A third party is neither a business or a service provider or a contractor, and it's usually a marketer. And any information you give to a third party should also, in my opinion, have as much contractual protection in it as possible. And then there's a fourth category under the CPRA, basically that it's none of the above. And they basically need similar terms to a service provider, as well as a certification that they understand the terms of the contract. So I'm not going to go over these. These are the following slides are really a little more particular about the specifics that need to be in the contract, including vendor's duty, and some of these are my own embellishments because I've dealt with these issues for a long time. They should notify, if there's a data breach of a vendor, they should really notify the the contractor, the business to whom the vendor does business with, within 24 hours, and provide a 24/7 contact person to assist, allow physical access to facilities, facilitate interviews with a service provider. They'll give you some pushback on this. This is not purely CPRA, but it's best practices. If a vendor gets a consumer request, for example, to delete, the vendor must delete if it receives a request itself. And if it gets a consumer request from a business to delete, it's got to comply with what the business says and delete. If it gets a request from the consumer itself, it can either delete it or it can tell the business that the consumer wants it deleted. And again, subcontractors have responsibility. All right, well, next is employees. We're going to go over it a little bit. I hope nobody minds too much. But employees have a very, very broad description, or lack of a better term. We have a very broad area from which we take employee data: job applications, resumes, CVs, the employment contract itself, an independent contract agreement, a performance review, disciplinary records, photos used for ID badges, organizational charts, marketing, websites, biometric, data used for timekeeping, either a face print or a fingerprint, backup files, information on devices, browser history, payroll information, benefits administration, all types of information is collected from employees. So take a look at this carefully, and it should jog some other things perhaps that you collect that maybe is not in there, or maybe this indicates more than you actually collect, but it's something you need to look at very carefully. Information for the purpose of profiling, which we talked about earlier. So employers need to get a notice of collection too. And again, I didn't touch on this directly, but there's a very broad definition of employees in the CPRA. This is also in the CCPA, but employees include employees, job applicants, owners, officers, directors, contractors, and that would be the B2B people, and medical staff members. So it's a very broad category. So all the information you have on any of those people, or any of those categories of people, is going to be subject to the CPRA if the business is subject to the CPRA. Employee right of action is the same as the consumer right of action for a data breach. Reasonable security procedures, again, that's something that's going to be a tribal issue of fact, but you need to sit down with your IT department and determine whether or not they have reasonable security procedures in place for the purpose of protecting the particular data that you have. And some data is more sensitive than others, and so you may require a heightened security procedure. So you're going to have to do some very intense data mapping. As I indicated, they're going to vary depending on the type of data you have. And again, there's lots of definitions of what is and what is not reasonable, but ultimately it's going to be a tribal issue of fact. And you're going to have to adopt the industry best standards. So look at it, whatever businesses in your industry are doing, or have your IT people discuss it with them and see what's appropriate for you. So with that, I'm going to conclude. What I have after this is just basically a 30,000-foot overview of what I consider to be best cybersecurity practices. I'll skip through that, but you also have physical document security practices. Don't forget, you carry documents. You may well have physical documents in boxes, and if you do, you better make sure they're in a secure location and ensure limited access to that location. And document retention policy, which we discussed. And yes, we will be sending a copy of the slide deck to everybody. You have to be able to determine what you're going to keep and what not, and destroy or at least anonymize data that you no longer are going to use, because it's in your own interest to minimize the data you collect. Okay, you also have email best practices for social engineering. Please take a look at that. I'm not going to go over in detail. I think you know that, but it's critical because 90% of malware is planted through email phishing exercises where someone clicks on a link. So employees need to be very specifically trained, and these are all going to be your reasonable security procedures. Passwords, password best practices need to be adhered to. Changing passwords frequently, not using derivative passwords, using separate passwords for different systems, that's critical. Lockouts for a number of attempts for a set time period, and so on. And of course, if there's a data breach, all passwords, including employees, must be changed. Cyber insurance, take a look at that. All I can tell you, this was done before COVID. Cyber insurance has doubled, the premiums have doubled, and so many companies are now getting out of it since all of the data breaches that occurred after and during the COVID lockdowns and people working from home. Arbitration agreements are incredibly important to the extent they're enforceable. So you need to look at that and discuss that with your lawyers, because if there is a data breach, you may be able to compel arbitration for consumers anyway. And work from home issues, of course. And these are important. Prohibit the use of Wi-Fi and laptops and cell phones. VPN with strong end-to-end encryption. Use all your employer-provided security software. Turn off Siri and Alexa. They're listening at all times, and you never know what's going to come up. You may be talking about something with your husband or wife or your son or daughter, and next thing you know, you get a pop-up ad because Alexa heard you, even though you don't think Alexa heard you. Pretty scary. So anyway, sensitive data should be only available on a remote need-to-know basis. Prohibit working from public places where third parties can view screens. All common sense, and you probably all teach this, but these all go back to reasonable security procedures under the CPRA. And any one of these places can be places where a data breach will be the source of a data breach. If somebody sees your screen or something else. So lots of things going on there. So questions. I've got a number of questions here, but I think I've answered all of them.
Thank you for joining us for today's presentation. We will now end the webinar.